Welcome to this lecture of the Recognize project. My name is Misseri, and I work as an assistant professor at the Department of Philosophy of Law at Alicante University. My goal in this lecture is to offer you a simple introduction to the concept of defeasibility, what are its implications and challenges in the field of legal theory, and finally to introduce a particular approach, the post-positivist one, to the challenges defeasibility raises for our understanding of the practice of law. That's why the title of this presentation is Defeasibility in Law, a very brief introduction to its challenges. Having in mind that goal, I have divided this lecture in two parts. This video constitutes the first part of the lecture in which I'm going to address the very basics of the concept of defeasibility and to explain how it is understood in the context of legal studies by describing the main standpoints about the topic. In the second video, in the next one, I'm going to address Manuel Atienza and Ruiz Manero's approach to defeasibility in their post-positivistic theory of law. In both cases, my main source for this lecture is the comprehensive work titled, edited by Jordi Ferrer-Beltran and Giovanni Battista Ratti, entitled The Logic of Legal Requirements, Essays on Defeasibility, published by Oxford University Press in 2012. But in this particular video, I'm going to reconstruct some of the debate between a Spanish legal scholar, Juan Carlos Bayón, and Argentine scholar, Jorge Rodriguez, entitled Normative Relevance in the Justification of Judicial Decisions, published in Spanish by Universidad del Externado de Colombia in 2003, and some of the history of divisible reason and philosophy from extracted from Robert Kuhn's 2021 entry on the Stanford Encyclopedia of Philosophy. So let's start with the definition of defeasibility. If we look at the dictionary, defeasible is defined as something capable of being annulled or made void, as a claim or norm, for instance. The word comes from Anglo-French défaisable, something that can be undone, destroyed. And that comes from Latin dis and facere, to make, and habilitas, skill or capability. So this capability of being undone or become overcome has become the object of study of different fields such as logics, epistemology, moral philosophy, artificial intelligence studies or computer science, and of course legal theory. Depending on your tradition, we could equate the term legal theory to jurisprudence or philosophy of law. And all those fields are related with different problems of defeasibility, depending on what is the thing that is annulled or made void. Is this the reasoning? Is this our knowledge? Is it our moral knowledge? Or some algorithm or legal components, as we will discuss later on. Another way of defining defeasibility is the one provided by Argentine logician Carlos Alchurron. For him, defeasibility is the property of some conditional propositions of being liable to implicit exceptions that cannot be number ex ante. I repeat, defeasibility is the property of some conditional propositions of being liable to implicit exceptions that cannot be numbered ex ante. That is related to the non-monotonic character of our daily life logic. Here, non-monotonic means that the antecedent is contributed but not sufficient for the consequent. Let's provide an example. For instance, I could say, if I finish my paper on time, then I will participate in a congress in Slovenia. I finished my paper on time, therefore I will participate in a congress on Slovenia. This is the form of modus ponens or modus ponens ponens. If A, then B, A, therefore B. But we could add some implicit exceptions to the conditional premise that will affect the truth value of our conclusion, showing that A, if I finish my paper on time, was only a contributing condition, but not a sufficient one for participating in the Congress. For instance, I could add, provided that I am alive at that moment, or provided that the Congress does not get cancelled by a new COVID-19 wave. But the problem is that we cannot always foresee all the exceptions. That is why we tend to treat the defeasible arguments as tentatively conclusive, although they can lead us to false conclusions, even when they are compounded by true premises. How that defeasibility affects our conditional statements, their interpretation, and also their application is one of the main challenges we face. If the conditional is a rule, then the problem becomes more urgent, we could say. For instance, what to do if a self-driving car encounters an exception to the algorithm? Or what if a judge applying a rule is not sure if there is a place for an exception? Among the first thinkers to reflect on the last problem, according to Schauer, we can quote Plato or his disciple Aristotle. Both were deeply influential ancient Greek philosophers who lived and worked and wrote many important texts for Western thought during the 4th century before the Common Era. They were very influential on metaphysics, and in the case of Aristotle, also on logics, and both influenced on politics and ethics. Particularly, Aristotle, in his logical works, later on named Organon, made a distinction between deductive logic and dialectical reasoning. If the former was the scientific way of thinking, the latter was the one used on a daily basis, and even being defeasible did not make it useless. The idea of defeasibility of the rules appears in his book Nicomachean Ethics as a key to guarantee epieikeia, or in modern Greek, epikeia, or equity. That is, the possibility of correcting the bad outcomes of the application of a general rule to particular cases. This was already present in Plato's work, as for instance, the statement, but the analysis of Aristotle is more systematic. 24 centuries later, it was a British legal philosopher, Herbert Hart, who brought back attention to defeasible reasoning in the law, especially within the Anglo-American common law tradition. Hart pointed out that judges must take into account exceptional circumstances in which a legal principle cannot be applied at all or must be applied in a weakened form. Hart, says Kuhns, refers explicitly to conditions that can defeat the claim that the contract exists, even when the standard definition of contract is satisfied. A defeasible logic is needed because a judge is required to make a judgment on the basis of an incomplete set of facts. The idea of defeasibility is present in the work of another British scholar, Stephen Toulmin. In his book, The Uses of Argument, argues for the importance of distinguishing between warrants and rebuttals. The formal theory of argumentation has proved a fruitful ground for the development of models of defeasible reasoning, and also has an influence on the legal scholars we will discuss on the second video, especially in the post-positivistic view and argumental view of Manuel Atienza and Juan Ruiz Manero. I made this slide with some of the books and the dates when those authors have mentioned the problem of defeasible reasoning. I need to mention also Pollock, an American philosopher influenced by the work of Chisholm, who developed a theory of prima facie reasons and defeaters of those reasons. So, during the 20th century, the problem of defeasibility and defeasible reasoning gets some impulse, we could say. So, once we have a glimpse of the history of this feasibility, let's get back to its implications for law. We can extract a definition from Ferrer and Ratti's work. They said law or its components is liable to implicit exceptions which cannot be specified ex ante, that is, before the law's application to particular cases. We mentioned this definition. And also they said contemporary jurists and jurisprudence tend to accept that legal standards are somehow defeasible, that is, that they are open to implicit exceptions, which cannot be exhaustively listed ex ante and accordingly do not provide conclusive, all things considered obligations, but rather prima facie ones. End of quote. So these authors claim that there is a set of phenomena that are related to defeasibility that are well accepted, but there is no agreement about the consequences of that acceptance and all the implications they have. A basic way of defining the main problem is that defeasibility is a property of conditional propositions and norms. A conditional proposition is defeasible when it is liable to implicit exceptions, as we mentioned before. In the field of legal reasoning, this has important consequences because norms can be represented as defeasible conditionals. Many elements of law can be conceived as conditionals, and then the problem of defeasibility appears as a relevant one. If we ask ourselves about the relationship between law and defeasibility, according to Ferrer and Ratti, there are three main positions to take into account. First, the first standpoint claims defeasibility is necessary for conceiving of law. Second, defeasibility is impossible in the context of law. And third, defeasibility is contingent. It depends on the legal system. The first position is defended by Italian legal scholar Giovanni Sartor, who claims that defeasibility is an essential feature of legal reasoning. The second position is supported by scholars as the Spanish Rafael Hernández Marín, who claims that defeasibility is an obscure notion. It's just a curiosity in the study of law and nothing else. Or the Argentine legal scholar Jorge Rodriguez, who claims defeasibility is not useful in the context of law because it makes inference impossible. We will develop a little bit Rodriguez's criticism in our reconstruction of his debate with Juan Carlos Bayon. Finally, the third position is held by American scholar Frederick Shawa, who claims that defeasibility is an ad hoc adaptation to avoid rule-generated outcomes that we could consider erroneous. Shawer traces back this idea to Aristotle's equity, epikeia, as we mentioned a few minutes before. But for the author of Playing by the Rules, defeasibility is not a feature of rules, not a property of rules, but an attitude of decision makers of how to treat the rules. Here at least two kinds of problems are raised. One has to do with the identification of law and the other with its application. Both are related, but they could be analyzed separately. The first linked the problem with the issue of how determinate is the legal system, because if we cannot know ex ante the exceptions of the norms, then law may be considered as indeterminate. That is why some authors, such as Jorge Rodriguez, deny the existence and usefulness of the concept of defeasibility in law, because they think if we accept the defeasibility of our norms, whether rules or principles, the whole system becomes indeterminate. What really happens, according to Rodriguez, is that some rules fall short from a case and others could be contradictory. Other authors, like Spanish legal scholar Juan Carlos Bayón, following Herbert Hart's work, believe that law is partially indeterminate. That is why the concept of defeasibility is useful for legal theory. According to Bayón, we can extract three main ideas from Hart's work on defeasibility. First, the presence of defeasible norms in law is contingent. Second, in a legal system, um, defeasible and indefeasible norms can coexist. And finally, a defeasible norm makes the law indeterminate about the factual aspect of the norm. Again, Argentine scholars Jorge Rodriguez and Germán Zúcar argue against the feasibility of the norms, holding that what is defeasible is our belief about the norm, and not the norm. But Bayón explains that two norms are defeasible when the existing interpretative conventions do not predetermine preference relationships between them for the cases of collision. For a positivist legal scholar, law is conventional, a practice. The limits of the conventions, then, are the limits of law. In their debate, Bayón and Rodriguez clash on two different positions about the following three theses. Bayón accepts these ones and Rodriguez rejects them. First, the first thesis. Divisibility is useful to reconstruct a possible way of identifying law. Second, some of our current practices imply divisibility. Third, the possibility of divisibility in law is compatible with legal positivism. As one can infer from this debate, it is not only about the role of divisibility plays in law, but also about how that concept affects our theory of law. For Bayón, law is compounded about divisible and indivisible norms. What guarantees the determination of law are interpretive conventions, for instance, the rule of closure based on relevance. According to the legal scholar, this view is superior to formalism, understood as law compounded by pure indivisible norms, and it is also superior to skepticism, as conceived of as compounded by pure divisible norms. But there is no agreement about the nature of those divisible elements of law. Some legal scholars claim that law is formed by rules and principles, being the former indivisible and the latter divisible. The problem is how those two kinds of elements are related and the role played by divisibilities in that relationship. If rules depend on principles, then the whole legal system is affected by divisibility. In contrast, if rules are independent from principles, then principles could be considered as irrelevant. In our next video, we will discuss a particular approach to divisibility considered as post-positivistic, in the sense that recognize law as a social practice oriented by values and purposes, and compounded not only by a level of rules, but also by a level of principles. This is a Dworkinian influence on the authors Manuel Atienza and Juan Ruiz Manero. Thank you for listening. I hope to see you in part 2.